Hello everyone, here I am Lucky from the Lucky Law. Today we are going to dissect the Haryana judiciary exam which is held in 2017 and we'll discuss to clear the PD exam on how many topics we have to focus. There are some kind of a category of a PD judiciary exam and same is here, but a little bit Haryana is different. Most of the question is asked in this exam is a bare act based. If you are a very good command on the bare act, then you easily can crack this exam. And the second category is your case law based question. If you have a good command on the case law, then also it will be easy to you. For the case law, you have to go through the Supreme Court or high courts, especially Punjab and Haryana courts, high courts, the landmarks judgment, whichever it is. The third category is your number based question. Number based question, they will ask you some kind of a direct question on the direct sections. They will ask you the punishments. They will ask you the time period which provided, and etc. Fourth category is your application of the law. You have to apply law on the question and find out the answer. And then you have a general awareness. For general awareness, it is better to be confine yourself into the law or a very much current affair or international or national, which is a very remarkable to the history of the world or present scenario. All these kind of a question is generally asked in the Haryana judiciary exam. Now we will discuss the exam. Here is the first question which is asked from the CPC, and the question is a very little bit, if I say, is very straight with the bare act language. The language of this question is if you match the order 23 rule 3, then there is in the foot of the order 23 rule 3 there is a same language which generally be left, but they Haryana judiciary exam they have asked to us a compromise which is voidable under the Indian Contract Act 1872. Same language you will find on bare act shall not be deemed to be dashed within the meaning of order 23 rule 3 of a code of civil procedure 1908. That is lawful. The answer of this question is lawful. And then we come to the second question, where an appellant has withdrawn the appeal preferred against the decree passed ex parte, a subsequent application filed under order 9 rule 13 of the code of civil procedure 1908 shall be maintainable. Definitely it will be maintainable because he has withdrawn the appeal preferred against the decree passed ex parte. Then he is free to file the application under order 9 rule 13 in the civil court, mean to say in a trial court. Then we have a question number 3 which is also from the CPC. Which provision of the CPC 1908 debars a tenant from filing interpretive suit against his landlord? This is the question which I am talking about directly from the section. If you read the section carefully or you remember the section carefully, then you can solve this question. Otherwise it is very hard, in fact very hard, because this question is very ingenuine. See, the provision of if I detailed about the interpreter suit that is given in the section 88 of the CPC, and order 35 is talking about the interpreter suit. In the section or in order 35 there is a detailed procedure how we can file a interpreter suit. For interpreter suit there are order 35 rule 3 as given here or order 35 rule 4 is no talk about the debar a tenant from filing interpreted suit against the landlord, but it is the Order 35 Rule 5. Order 35 Rule 5, who debars a tenant from filing interpreted suit against his landlord. Then we come to the Section 4. Section 4 is a composition of an offence under Code of Criminal Procedure 1973 will result in of the accused acquittal. I am very confused when I appeared in this when I take this question, because the composition I don't know why, but I never hit in my mind during the examination that composition may be possible to nearly meaning to the compoundable. Definitely, if any offense is compounded, then the accused is acquittal. But in case of a plea bargaining, there is not acquittal, which is given in under section 21A, under part of the 21A of the CRPC. So now we take the fifth question. In one trial, X is convicted against which or no appeal lies, whereas a conviction against Y is appealable. Whether X can file an appeal against his conviction? Definitely he can file an appeal. Its answer is B. Under section dash of the Code of Criminal Procedure 1973, it is mandatory for a police officer to inform the person arrested without warrant about the right of the bail if the offence is not non-bailable. Definitely under section 50, it is the duty of the police officer who arrested the accused without warrant, that he have to tell if the offence is a non-bailable. The part of the arrest in the CRPC is a very, very, very important. Never go to the exam, never appear in any judiciary exam without having command of this arrest chapter, which is very important, very relevant. Every section from the 41, beginning of the 41 is very important. Now we come to the question number 7. X, a blacksmith, is seized by a gang of dacoits and forced by a threat of instant death to take his tools and forced him to open the door of Y's house. The dacoits then looted Y's money, jewels, and also killed Y's son, Jet. What among the following offences under Indian Penal Code 1860 has been committed by X? No offence. It is because there is the one thing. X, a blacksmith, he have a never intention to commit such kind of offense, and in according to the IPC, whenever there is a absence of a mens rea, it means any offense done without mens rea is not an offense under Indian Penal Code. So X blacksmith, he is threatened, even the dacoits are threatened to the X. So X never intend to do that offense, never any malified intention, and no mens rea, it means no offense done by the X. Now we goes to the section question number 8. For constituting an offense of abduction under Indian Penal Code 1860, the abducted male person should be. Here is the I have to say, the section 362 of IPC nowhere mentioned the age. It means it's of any age. As much as I thinking about this question is of any age, and the answer is D. Because in the case of kidnapping, there is a mention of age. There is a two type of kidnapping. One is from India, outside the India, and the second one is a kidnapping of any person who is less than 18 years. There is a mention in kidnapping. There is a clearly mentioning of the age in the kidnapping, but not in the abduction. Then it means abduction can be done of any person. Okay, section now be question number 9. How many minimum number of persons are required to constitute the offense of writing? Simply, it is the writing is defined under section 147 of the IPC, and the minimum 5 persons is required. Now it's a very, very important question from the side of if I say practice or for the judiciary exam, because here the Panchila proof which is given in a Shard versus State of Maharashtra by the Supreme Court It's a very important and a very good question. There are the five Panchshila. If I read, Supreme Court held that the circumstances from which the conclusion of a guilt is to be drawn should be fully established. This is the first Panchshil. The fact so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other to say they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of a conclusive nature and tendency. They should be exclude every possible hypothesis. Hypothesis except the one to be proved. And number fifth is there must be chain of evidence so complete as not take any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human possibility that must have done by act. Must done by act. These are the Panchshila which is given by the Sharad versus State of Maharashtra. A very landmark judgment for in the view of circumstantial evidence. Now we come to the section question number 11. What minimum number of a witness are required to prove offense of dacoity in a trial? 5, 8. Judge directs how many witnesses are to be. No particular number be of the witness because section 134 of the Indian Evidence Act talks about it. Now we will move to the question number 12. Here, the examination after the cross examination of a witness by a party who has called him is called re-examination. Section 137 of the Indian Evidence Act talks about it. There are three kinds of examination. First is your examination in chief, then come to the cross examination, and thereafter re-examination. Re-examination आपका if I said तब होता है जब आपका there is a new fact arise in the cross examination. Just to cover up that, just to revert that fact, you have to re-examine your witness. Which article? Now the question regarding the Constitution of India. Which article of the Constitution of India provide a constitution safeguard to the civil servants? Straightway, these are the number-based question. Section 3, so Article 311. What kind of a jurisdiction has been conferred under Article 143 of the Constitution of India upon the Supreme Court? If I say it is the advisory jurisdiction, but nowhere here is a mention appellate jurisdiction, writ jurisdiction, original jurisdiction, supervisory jurisdiction. So the answer is E, none of the above. A counterclaim shall be deemed. Now the question number 28. X and Y are a husband and wife having a son and a daughter. They have adopted a girl child. Whenever any husband or a wife or any couple have already son and daughter, then according to the section 11 of the Hindu Adoption and Maintenance Act, if they adopt a girl and they already have a girl, if they adopt son and already they have a son, then this adoption is void. Then we move to the section 29, which section of the Hindu Succession Act 1956 lays down the order of a succession among the agnates and this is section 12. I already told you this is the number based question. If you have a good command on a bare act, and you can solve this kind of question. Now, if at the time of solemnization of marriage, wife has been subject to the recurrent attacks of insanity under Hindu Marriage Act 1955, the marriage will be voidable. Section 12 of the Hindu Marriage Act, where the clearly mention about the voidable marriage. Now 31. These are a very state-based question. Unavoidable delay up to in presentation of a document for a registration under the Registration Act and 1903 may be condoned by a 4 month. Which of the following is oblique are goods according to the Sale of Goods Act? It is the mentioned in the Sale and Goods Act. Question of a Sale and Goods Act 1930. Stocks and shares. Alienation of the minor's property made by a natural guardian without the previous permission of the court under section 8. Clause 3 of Hindu Minority and Guardianship Act 1950 will be voidable at instance of the minor. Definitely. Mean to say, whenever minor is under 18, then he can file a suit or revert that property to him. Pecuniary limits of the jurisdiction of the civil judges are determined under the Punjab Courts Act 1918 by High Court. Now then section question number 35. Who among the following was the first bar? Lal Bahadur Shastri the first. These are the some general knowledge question which we read from the very childhood. Now it is the scientific question. Decibel is the intensity of it is the measurement of sound, intensity of a sound. Just suppose distance is measured by a kilometer meter, same here is the decibel. And this is the one other GK question which related from the Quit India movement. It is a Quit India movement 2 against social ills has been launched in Maharashtra. Now we move to the question number 38. This is the question is directly is based on the number that to compel the attendance of a person to whom a summon has been issued under section 30 of the CPC procedure 1908, the court is empowered to impose upon him fine not exceeding 5,000. Read. Remember, 5,000. Now, which section of the Code of Civil Procedure 1908 state that the place of a trial is to be deemed to be in open court? 153b. Nothing to understand. Decree of a restitution of a conjugal right may be enforced under Order 21 Rule 32 of a Code of Civil Procedure 1908 by attachment of property, detention in a civil prison, imposition of a fine, all of the above. In generally, there are these attachment of property and detention in a civil prison. These all are given in the section for the satisfaction of the decree. But as much as satisfactory is your answer is your attachment of property, then you have, if an indigent person succeeds in the suit at the due amount of the court fee shall be recoverable from any party ordered by the decree to bear the same. Order 33 Rule 10. There you can find this answer of this question. Order 33 Rule 10 specifically mention who will pay, when will pay, how will pay. Now section 42. Which of the following section of the Code of Criminal Procedure 1973 declare accused person to be competent defense witness? 315. Which of the following is an incorrect response in the light of the Code of Criminal Procedure 1973? Inquiry is conducted after framing of charge. Because there is some kind of if I said the trend in the trend not, it is a procedure of the CRPC, Code of Criminal Procedure. First of all, there is an investigation, then B, there is an inquiry, and the moment the inquiry stops, the trial got begin. Mean to say, inquiry is conducted after framing of charge. There is no inquiry after the framing of the charge. Now we move to the section number 44. Section 48 of the Code of Criminal Procedure. These are the inherent power is in a Code of Criminal Procedure which is given to the High Court is under 482. It is not available to the trial court or first appellate court. It is directly to the High Court. If I say, not to the Session Court, not to the Chief Judicial Magistrate, not to the Judicial Magistrate of the first class or the second class. But in the civil procedure code, there is a inherent power which is given under section 151 is available to the trial court, first appellate court, second appellate court. This is a difference regarding no court shall take a cognizance of an offence after the expiry of a 6 month. Very simple number based question. Section 73 of the Indian Penal Code, it is the solitary confinement. You just go through that. 73, very easy language. This is a little bit technical question. Question number 47. All Indian citizen murders a French citizen in a Paris. He is found by a Indian police in a Mumbai. He previous sanction of a central government can be prosecuted in a Mumbai only. It is a very general illustration, mean to say if any offence has done outside India, the moment where first he found or got arrested, in that place his trial will begin for that offence. A finds a purse with the money not knowing to whom it belongs. He afterward discovers that it belongs to B, but he retains it. It means it is clearly the misappropriation. I must say criminal misappropriation, which is the listed offence in the IPC under section 403. Then 49. Which of the following section of the Indian Evidence Act 1872 makes an accomplice a competent witness? It is a section 133, option number D of this section of this question, which clearly states that the accomplice is the competent witness. Now, the question number 50. Which of the following section of Indian Evidence Act 1872 prescribe a condition for making oral admission as to the content of the document as relevant? 22, very bare language, straightway question. If you read it, then we have 51. Which of the following section of the Indian Evidence Act 1872 make a confession of a co-accused is admissible? 30, bare language. In case any question arises as to the age of the judge of the High Court, the decision of which of the following authority shall be the final? It is the President of India. Which of the following is not among the language recognized under the 8th schedule of the Constitution of India? None of the above. Sindhi, Dogri, Santhali. How many fundamental duties are prescribed? It is the 11 fundamental duties actually, and nowhere here is a mention is the 11. A Pakistani citizen residing in India cannot claim a fundamental right, freedom of a trade and a profession. It is because Article 19 is given to the only Indian, and it is not available to the foreign citizen. What will be the limitation period for instituting a suit for which no specific period of limitation is provided under the limit? It is 3 years. Then we move to the question number 57, 13b. There is a amendment according to the let me tell you first of all what is the 13b. It is the divorce by the mutual consent, which inserted in Hindu Marriage Act in 1976. It means if husband and wife both are ready and they want to separate themselves, and then there is a divorce by mutual consent. Now there are lots of authorities is come in the given by the Supreme Court. There is a Arvind Kaur, Arvind Kaur versus Amindeep. Even there is a judicial separation time of 6 months is can be waived if there is no chance and the marriages cannot be reversed according to the irreversible theory. Then we have a section 58. Which of the following is not a mode of a dissolution of a firm under Indian Partnership Act? C. Dissolution by agreement is given in the section 40 of Indian Partnership Act. The compulsory dissolution, section 41 Indian Partnership Act. Dissolution by court, section 44, but nowhere is given the dissolution by registrar. A registrar has no power to dissolve the partnership firm. So the appropriate option of this question is C. Now the question number 59. Under the section 16 of SRA 1963, in a suit for a specific performance of a contract, the plaintiff must ever performance offer a readiness and a willingness to perform. What is the meaning of a readiness? Plaintiff capacity including financial. Mean to say at least plaintiff ऐसा होना चाहिए कि वो जो कंडीशन उसने मतलब जो कॉन्ट्रैक्ट में दे के रखी है उसको परफॉर्म करने के लायक तो होना चाहिए. Then we say, then this is the requisition, this is the prior condition for section 16 if you want to applicable, and the answer is the simply B. Now the question number 60. An agreement between the landlord and the tenant for the payment of any sum in addition to the fixed fair rent shall under Haryana Rent Control Act 19 null and void. When consent to an agreement is caused by a misrepresentation under Indian contract, it is avoidable at the instance of the parties. Under section 18 of the Indian Contract Act. Under section 18 of the Indian Contract Act talks about the voidable contract on the basis of misrepresentation. There are some other grounds like caution, mistake, undue influence. If they are exist in the contract, then the contract is straight away voidable. Qui facit per allum facit per se. These are the maxim which you have to cram or do anything. He who acts through another acts himself. Now we move to the question number 63. It is a little bit technical. If you good in the partition or succession act, then you can do it. See, if a Hindu male die interstate, there are two type of a succession. If I say one is your succession through instrument by and one is your interstate or testamentary succession. Testamentary succession में ऐसा होता है कि there is some kind of instrument, you can say gift deed or bill, but in interstate there is no such kind of instrument, but it is devolved under the Hindu Succession Act, and there is some kind of set procedure how there will be, first of all there will come the first class legal heir, then second class, then agnet, then cognate. Here is the first for this question we have to look out the who are the first class legal heir, and they are in this question is mother and the son. Only if there is a first class legal heir alive, then the property will be devolved only on the first class legal heir. Property never goes to the second class legal heir, never goes to the agnet, never goes to the cognate. So the property here is the first class legal heir are who are mother and son. So the property will be devolved half and half, and the appropriate option of the question number 63 is D. Now the very straightforward question: which section of the Registration Act 1908 makes it compulsory to affix passport size photograph and fingerprints upon the document to be registered? It is section 32A. A warranty as per section 12 of the Sale of a Goods Act 93 is a stipulation collateral to main purpose of the contract. Who among the following under a Hindu Minority and a Guardianship Act 1956 will be the natural guardian of minor wife's person? That is husband. It's a very good question, and very generally asked in the lots of judicial exam, different states judicial exam, that who is the guardian of the minor girl? It is husband. Who? It is the husband. Now we have the next question. It is a general knowledge question. Yad Vashem is an Israel Holocaust memorial. I am also not aware about this question. This is the WADA, World Anti-Doping Agency. It's some kind of a agency where the doping is if done by the any player, then they will find out it and punish to that player. Sir Creek, a dispute is between India and Pakistan. It is the tidal estuary. It is in Sir Creek line. It is somewhere in in sea and near to the Gujarat. If you find out in the map, Google map, then there is you can find out it is very easily. It is also a GK question. Sudhiram Cup is associated with the badminton. This is a CPC question. The proposition under order 18 rule 2. It is a order 18 rule 2. In this we have to supply the copy of the written argument earlier to the opposite party, and the option of the first is correct in the rest of his. I remember this question and I done it very gently and I made a score by this question. Now we have a question number 72 again from the CPC. Very much good question. When the state way, if I say the where question where an interim injunction has been granted under order 39, the civil procedure code, without notice to the opposite party, the court shall make an endeavor to finally dispose of the application within the 30 days. Here, let me tell you the one difference: shall and may. Whenever there is a may is written in the bare language, then it means the court has a discretionary power. But where there is a shall, then court has no power. Court is bound to do that. Which of the following provision of the Code of a Civil Procedure 1908 deal with the attachment before the judgment is order 38 rule 5. If trial court is satisfied that the convict intends to file appeal, it shall release him on bail. Under section 389 subsection 3 of Code of Criminal Procedure 1973, convict is on bail and awarded is the condition is here that if it is above 3 years, then there is a no provision, then court cannot exercise to grant the bail under this section 389 subsection 3. Now we move to the question number 75. In the Indian Constitution, criminal procedure is a concurrent. There are three type of list. One is your union list, then your state list, then your concurrent list. Concurrent list, there is a, let me tell you what is the meaning of these lists. There is some kind of a specified, if I say there is some kind of a specified work or subject is given in this list, और इसमें पावर रहती है. जैसे यूनियन लिस्ट, इफ देयर इज अ सब्जेक्ट इज मेंशन इन अ यूनियन लिस्ट, देन इट इज द ओनली पावर टू द यूनियन लिस्ट, सेंट्रल गवर्नमेंट. और इफ देयर इज सब्जेक्ट लिस्टेड इन द स्टेट लिस्ट, देन द पावर इज रिगार्डिंग दैट सब्जेक्ट इज गोज टू द स्टेट गवर्नमेंट. एंड इन कॉन्करेंट लिस्ट, both state and the union list exercise the power. Suppose here is a constitution criminal procedure, then it means if there is a amendment, if the state government wants to amend some provision of the criminal procedure, then the state governments can, because the criminal procedure code is given in concurrent list. A proclamation under section 82 of a Code of Criminal Procedure 1973 shall specify time for not less than 30 days from the date of publishing. Under the section of a Code of Criminal Procedure 1973, court can grant adjournment subject to the payment of cost. None of the above आएगा इसमें. This is a very lengthy question. If in a complaint case it is made to appear to the magistrate, very good question. And regarding to the judicial exam and also to the practice, इसमें मैं सीधा बताऊं कि अगर जैसे सपोज आपने कंप्लेंट फाइल करके रखी है अंडर सेक्शन 200 ऑफ CRPC, बट उसी सेम ऑफेंस पे आपका पुलिस भी इन्वेस्टिगेट कर रही है, तो आपका जुडिशियल मैजिस्ट्रेट के पास आपके दो ऑप्शन रहते हैं. नंबर एक कि वो दो ऑप्शन कि वो जो प्रोसीडिंग चली होती है कंप्लेंट वाली जो आपके थ्रू चली होती है उसको स्टॉप कर दे. एंड द थर्ड ऑप्शन इज योर call a report from the investigation officer, and the appropriate answer is 2 and 3. Judgment in Mehboob Shah versus Emperor, very landmark judgment that is given by Privy Council. And a year 1945 Privy Council. Let me show you. I let me I find out for you. Let me tell you. Yeah. See, Mehboob Shah versus Emperor case. Very important case. Fact of this case was कि मैं मोटा मोटा बता देता हूँ आपको. इस केस में ये हुआ था कि 25 अगस्त ऑफ 1943 जैसे सूर्योदय हुआ एट सनराइज अल्लाह डैट deceased with a few other left their village by boat for cutting reeds growing on the bank of the Indus River. About a mile downstream, they saw Mehboob Shah, father of a Bali Shah, absconder, who warned them against collecting reeds from a land belonging to them, ignoring which they collected a reed from their land. And उसके बाद क्या होगी? While returning, Ghulam Qasim Shah, nephew of Mehboob Hussain Shah, stopped them and pulled the boat with a rope and asked to return the reeds. Allah Dad picked up the lari from the boat and struck Qasim Shah. Qasim Shah then shouted out for the help and Bali Shah and Mehboob Shah came up. When Allah Dad had Hamidullah tried to run away, Bali Shah and Mehboob Shah came in front of them and Bali Shah fired at Allah, who fell down dead, and Mehboob Shah fired at Hamidullah, causing injuries. Issue इसमें यह था कि whether the appellant has been rightly convicted of murder upon the true construction of section 34 or whether a common intention to commit the crime which was eventually committed by Mehboob Shah and Bali Shah came into being when Ghulam Qasim Shah shouted to his companies to come to his rescue. And the court, when the Privy Council is a very great observation made. Ghulam Qasim had no common intention of killing any member of the complainant party, as he did no more than ask his companion to come to his assistance when he was attacked with the pole by deceased, and that he could not have been aware of the manner in which assistance was likely to be rendered to him, or his friends were likely to shoot and kill one man or injure another. Mehboob Shah and Bali Shah stood in different footing. It is difficult to believe that when they fired the shots, they did not have the common intention of killing one or more of the complainant party. If so, both of them are guilty. Common intention within the meaning of this section implies a pre-arranged plan. A very important word, that is the pre-arranged plan. And to convict the accused of an offence applying section, it should be prove that the criminal act was done in concurrent pursuant to the pre-arranged plan. There was no evidence and there were no circumstances for which it might be inferred that the appellant must have been acting in a concert with Bali Shah in pursuance of a concerted plan when he along with him rushed to the rescue of the Ghulam Qasim. The sole point which required consideration now is whether a common intention to commit the crime came into being when Ghulam shouted to his companion to come to his rescue and both of them emerged from behind the bushes and fired their respective gun. The appellant and Bali Shah had the same intention. The intention rescue Qasim if need be by using the guns. Evidence falls far short of showing that the appellant and Bali Shah ever entered into premeditated concert to bring about the murder. Allah Dad. Care must be taken to confuse same or a similar intention with common intention. Then the judgment comes very blunt, very fine judgment if I tell you. For the reason indicated above, their lordship have humbly advised his majesty that the appellant having succeeded in his appeal should be allowed and the conviction for the murder and the sentence of her death be set aside. This is the, if I said, all happen in Mehboob Shah versus Emperor. Now, which section of the question number 80, which section of the Indian Penal Code 1860 define a sedition? 124. A sedition is some kind of offense which is against the state. When you made some kind of a slogan or anything which is against the state, then you can be charged under 124A. The question is, as to the date of wife's birth and an entry in the diary of a deceased surgeon regularly kept in the course of business stating that on a given day he attended wife's mother and delivered her of a son is a relevant fact under which of the section 32 of the Indian Evidence Act clearly mention the constitutional validity of which of the following section of Indian Evidence Act 1872 has been upheld by Supreme Court in state of UP versus Deoman Upadhyay. Who among the following is empowered to finally determine whether a bill? It is the Lok Sabha Speaker. Which of the following is not a writ issued? A quo warranto. Quo warranto. There are a fine kind of writs: habeas corpus, mandamus, quo warranto, certiorari, prohibition. Every writ have a own effect. Now the question number 85. Which of the following section of the Limitation Act 1963 give a recognition to the concept of it? It is the section 27. Who among the following was in the news for the national anthem decision? Justice Deepak Mishra. It is the decision in which laid down that whenever there is a anthem, there must be paid a standing ovation. Then A and B jointly purchased a tea shop. Each of them contributed half of the expenses incurred for a pottery and a utensil. Then they leased out the shop and shared the rent equally. They are co-owner because if according to the Partnership Act, they will be partner. A and B will be partner if they do the business. But nowhere here they are doing business. Suppose for the business they will sell some kind of tea, anything. There must be a business. Then they will be partner. Here is no any kind of a business. They just rent it. Then it means they are a co-owner. Now the question number 88. To prevent the continuing breach in which the plaintiff has accused the court cannot grant injunction. Definitely. When consideration or object of an agreement is partly unlawful under Indian Contract Act, is void. Definitely it is void because it is mentioned in the Contract Act if the sum of the your consideration or object, which is if I give you example, मैंने आपसे अगर एक कॉन्ट्रैक्ट किया और मैं बोलूँ उसमें कि आप मेरे को चावल के साथ हथियार भी दोगे इसमें डाल के, चावल लेना इज नॉट एन ऑफेंस, चावल खरीदना इज नॉट एन ऑफेंस, बट द परचेजिंग ऑफ अ वेपन that is an offense. Illegally purchasing of a weapon, that is an offense. So the partly consideration or object of an agreement is a partly unlawful, then it is void. Now the question number 90. Under which section of the Hindu Adoption and Maintenance Act 1956 a depends claim for a maintenance? It is a section 27. Very number based question. A registration of the document containing contract to transfer for consideration any immovable property for the purpose of the section 53A of the Transfer Property Act. It is the recent amendment which is on 24th September 2001. According to this amendment, there is a registration is a compulsory. Section 16 of the Sale of Goods Act 1930 is an exception of the caveat emptor. Section 12 of the Hindu Minority and Guardianship Act 1956 does not oust the jurisdiction of a dash to appointing. It is the High Court. 94. In which of the following judgments the Supreme Court held that the irretrievable Breakdown of a marriage is not a ground for the divorce under Hindu Marriage Act 1955. Yet Supreme Court in exercise of extraordinary power under Article 142 of the Constitution of India can grant the relief. That is Anil Kumar Jain versus Jain case के नाम से जाना जाता है. Anil Kumar Jain versus Maya Jain. And one important case of the divorce, if I tell you, is the very recent, that is the Amandeep versus Harvind Kaur. In this case, what happened? The Supreme Court waived out the 6-month period and granted the divorce. Name the Governor General who abolishes the Lord William Bentinck. Then we have 96 number question. Order 5 Rule 9A is under which the following the provision of the Code of Civil Procedure 1908, a court may permit the plaintiff to effect service of a summons by hand upon the defendant. If I say, it is known as a Dasti summon, very popularly known as the Dasti summon. Now the question number 97, under section 34, deemed by it reasonable. Under section 34 the court 1908 court may grant a pendant light interest deemed by it reasonable. A court may, it means जो court को सही लगे. A court may pass a judgment and admission under order 12 rule 6 of a code of civil procedure 1908. What is the maximum sentence of imprisonment which can be passed on conviction in a summary trial under code of a criminal procedure? It is the 3 month. Now to the question number 100. ये क्वेश्चन सीधा पूछता है कि जो आपके 125 के केस होते हैं उसमें ट्रायल कैसा चलता है. तो इट इज़ अ समन केस और उसमें एविडेंस भी समन केस के हिसाब से चलता है. ये क्वेश्चन नंबर नेक्स्ट क्वेश्चन आपका, सेल ऑफ एन ऑब्ससीन ऑब्जेक्ट टू एनी पर्सन अंडर द एज ऑफ 20 ईयर क्लियरली मेंशन, दैट इज ऑफेंस अंडर सेक्शन 293. Which of the following section of Indian Penal Code is prescribed punishment for cheating? 417. Now the question number 103. It falls under the grievous hurt because according to this question, let me read for you. A, intending or knowing himself to be likely permanently to discover B's face. ठीक है, इंटेंशन है उसकी. gives B a blow, उसने blow दिया, which does not permanently disfigure B's face. उसने डिसफिगर तो परमानेंटली नहीं किया बी के फेस को, बट ऐसी पेन कर दी जिससे कि वो 3 वीक तक कराता रहा, मतलब उसको दर्द हुई. तो देर इज़ द 7 days in 1 week and 3 weeks, 7 into 3 equal to 21, and there is a ground of a grievous hurt. There is the mentioned in the section of 320 IPC. If there is any pain, any bodily pain, suffer of severe or a bodily pain which is more than 20 days, then it is a grievous hurt. So the appropriate answer is your grievous hurt. Then section 104, if a maker of a dying declaration survive his statement, can be used under Indian Evidence Act. It is to corroborate the testimony of maker, to examine it, never be used as a dying declaration. To contradict the testimony of maker if examined. Both are correct. Which of the, it is the dying declaration given under section 32 of the Indian Evidence Act 32(1). Which of the following section of the Indian Evidence Act 1872 is based upon the well-known principle? It is a section 110 of the Indian Evidence Act. It is the Haryana High Court case. So we must be focused on some important landmark cases of the Haryana. Constitution bench of a Supreme Court in a Jindal Stainless versus State of Haryana is a restriction. It is here is a given a restriction on the trade of a commerce. A suit for a compensation or malicious. Now we go to the question number 14. Sorry, we have done this. There is advisory jurisdiction. Now, question number 50. A counterclaim shall be deemed under section 3 of the Limitation Act 1963 to have been instituted. Counterclaim के लिए देखिए सीधा ये जिस दिन से फाइल होता है उस दिन से इसमें लिमिटेशन शुरू होती है. Counterclaim is given in, there is a, if I set order 8, rule 6 A to G. For your uh, if I tell you regarding the order 8 is generally made for the return statement, and then it is order 8 rule 6 that is made for the set off. There is a given detailed procedure regarding all this, and 6 rule 6A to G is made for the counterclaim. Section 15 of the Limitation Act 1963 exclude from a computation of a limitation all of the above. These are the section based question. What is the soul of that section that is asking this question? Now section number 16, Hindu Marriage Act 1955. 19 confer legitimacy on the children, both void and the voidable marriage. There is a clearly mentioned in the section 16 of the Hindu Marriage Act that these are the children born out from the void or voidable marriage are legitimate. Now the question number 18. How many additional grounds of a divorce are provided for the women under section 13 clause? There are the 4 grounds. There are the 4 additional grounds. These are the number based question which I told you earlier. If you have a command on the section where language, and the section number, then you can solve these very easily. Now this section number 19 is a question which asked from the Indian Partnership Act, and a very simple question. Where in a contract between the partners, no provision is made for a duration of their partnership or for a determination of their partnership. The partnership is at will. It is given under section 7 of the Indian Partnership Act, and the same bare language which you can find in the bare act. Now this is the next question is from the Specific Relief Act 1963. ये बोलता है कि हमें किसके अगेंस्ट जो है हम द सूट फॉर द रिकवरी ऑफ पोजेशन जो हम ला नहीं सकते हैं, एंड दैट इज द गवर्नमेंट. सेक्शन 6 क्लियरली states that no ambiguity in this, has no hardship in to understand the language of this section. Now the section 21, this one is a little bit technical, and if you able to understand what is the mandatory injection, then you can solve it. Some kind of a mandate, how you can how court will grant the little bit the procedure in section 21 has been asked. When to prevent a breach of an obligation, कोई ऑब्लिगेशन है किसी बंदे पे और जो है वो उसको कर नहीं रहा है, उसको ब्रीच कर रहा है, तो आप उसको कंपेल करवाओगे किससे? थ्रू द कोर्ट. क्या मांगोगे? मैंडेट मांगोगे अंडर सेक्शन 39 फॉर द मैंडेटरी इंजेक्शन कि वो करे. This is also the question of a civil CPC. Now the question is from the Haryana Urban Rent Control Act, a very number based question. The fair rent of the building or rented land fixed in the Haryana Urban Control of Rent. These are the 5 year. Then we have a continued guarantee may at any time be revoked by the surety as to the future transaction by the किसको notice जाएगा? Creditor. Whenever there is a transaction of money, there is a 2 things happen. There are 2 components. One is your creditor and the second one is your debtor. Debtor जिसने लोन लिया है और creditor जिसने लोन दिया है. Now the question number 24, what can a catalog of a books, listing price of each book and specifying the place where the listed book are available be termed? It is some kind of a offer, and it is the species of the offer which is known as an invitation to offer. In invitation to offer, what happens, suppose we take this example in a general language. बुक शॉप वालों ने क्या होता है, बुक वहाँ पे स्पेसिफाई लिस्ट बाहर अपनी शॉप के बाहर दिखाई होती है, और उसमें जो वो बताते हैं कि दिस इज़ द प्राइस ऑफ दिस बुक, दैट बुक जो भी है, एंड 20% ऑफ. दिस इज इन्विटेशन टू ऑफर. मीन टू से books are inviting us to give me an offer on what price you going to purchase it. We will went there, we made a proposal. If the proposal is accepted by the bookseller, then it becomes the promise and there is the agreement, and we will pay the consideration amount and then it become an agreement. This is the little story. Same thing is happen in the bidding, that there is some kind of a bid offer. Suppose somebody there is a bidding for the house or bidding for the property, then you go, you went there and you bid. When you bid, you are giving offer. When they And when it will be final, when the promise from the who are auctioning the property or a house, when they put a hammer, any custom which they are prevailed, or if they accept their amount, then it become promise, and we will pay the consideration amount, and it become agreement. If it is enforceable by law, then it become contract. This is the question number 24, which is from the contract. Now from the section 25, X being in a debt to buy the money lender of his village contract a fresh loan on a term which appears to be unconscionable, that the contract was not induced by undue influence is to be proved. Section 16 clause 3 of our Indian Contract Act very clearly mention that the person who is in the, if I say in a general language, that is a bestow power, who can bestow to the other guy, who is in the influential position, then they can be the person who in an influence position, he have to prove that the contract is not made under the influence. Now we will bend to the section 26. The principle of facts speak for themselves, res ipsa loquitur. These are the maxim based question, and you have to read the maxim for these, especially if you read the very good judges judgment. There is a, generally you will find this kind of a maxim. How many grounds of the divorce are provided for a Muslim woman under section 2 of the Dissolution of Muslim Marriage Act 9? There are 9 grounds. X and Y are a husband and a wife, having a son and daughter, they have adopted a girl, yet the adoption under Hindu. So the adoption under the Hindu Adoption Amendment Act 1956 is a void. This is the question of the section 11 of the Hindu Adoption and Maintenance Act, which clearly says that if we take this situation similarly, if you have a son or daughter, if now we move to the question number 108, which is from the Marriage Act, Hindu Marriage Act. Which of the following statement is incorrect in the light of the provision of a Hindu Marriage Act? It is the proceeding may be held in a camera on the request of the party. There is no mention that the party will request and the proceeding will held in camera. Contract of a life insurance is a contingent contract. Absolutely right. Conditional contract, contingent contract. First of all, you have to fulfill that condition, then the contract will be enforceable. A female Hindu inherited property from her husband. She died in the state. The said property shall, in the absence of any children or grandchildren of the deceased, devolved upon. See, if the property of the female is inherited from his husband, then it is devolved to his children, and if they are not, then it is devolved to the heirs of the husband. If the property is inherited from the father or a mother of the girl, from the parents, then it will be devolved in the absence of the children or husband to the heirs of the parents. Who is known as the saint of the gutters? It's a Mother Teresa, because it's a very gentle lady. Which High Court declared Ganga? It's a Uttarakhand. X residing in the Chandigarh published statement defamatory of Y in Ludhiana. Either in the case can be instituted, the complaint can be instituted in the either in Chandigarh or in Ludhiana. On production of a certified copy of the foreign judgment, the presumption as to the competency of the court under section 14 of the Code of Civil Procedure 1938 is the rebuttable presumption of the law. What does it mean? It's meaning that you can rebut it. There are the grounds given. If it is false in that, then it is a rebuttable. It is clearly mentioned in the section, if I am not wrong, section 13 of the CPC. There are the grounds when it is a competent, or when the judgment given by the foreign courts are admissible in have a same force in Indian court of Indian territory. Under Section 199 of the C Code of 1973, in a prosecution for a defamation of the Vice President of India's Session Court may take cognizance of such offence without the case being committed to it, but only upon a complaint in writing by the public prosecutor. Constitution Bench of a Supreme Court, in judgment of a Hardeep Singh versus State of Punjab, decided on a to the settled controversy regarding law containing in 319. If you if you see the section 319 of the Code of Criminal Procedure, it is the power to proceed against the other person appearing to be guilty of offence. Mean to say, power where in the course of an inquiry into or a trial of an offence it appears from the evidence कि भाई जिसके अगेंस्ट जो ट्रायल चला हुआ है वो नहीं है एक्यूज्ड इसमें, बल्कि एक्यूज्ड कोई और है. तो इसके बारे में एक सुप्रीम कोर्ट ने एक जो भी कंट्रोवर्सी थी सेक्शन में उसको बड़े अच्छे तरीके से इसमें सेटल किया है. जस्ट गो थ्रू दिस केस, इट विल एनहांस योर नॉलेज इन द कोड ऑफ क्रिमिनल प्रोसीजर. देन योर सेक्शन 117, इसमें वाइफ का रेप अगर हस्बैंड करता है तो वो 376 में देख के रखा है. वेरी law based question. A along with his gang member BCD holds X down and fraudulently takes X money and jewels from X clothes without his consent out of the following what offense? It's a robbery. A along his gang member B, C and D holds X down means they uses force. They uses force, take the property without his consent, forcibly. Then it is amount to, it is the robbery. Why it is robbery? Because it is the aggravated form of the extortion. Who wrote the book? The Argumentative Indian. It's Amartya Sen. Which of the following statements are incorrect in the context of a section 165 of the Indian Evidence Act 1972 regarding a judge power? Any party has a right to make an objection to such question to order. No party has a right. The parties have an inherent right to cross-examine a witness upon the said questions. No. Which of the following judgment Supreme Court laid down the procedure regarding a dealing with the objection as to the admissibility of the document and other item of evidence in the Bipin Chandra Panchal versus State of Gujarat? Which of the following directive principle of state of, it is the 48, which prohibiting the slaughter of the cows and calves and other milch and drought cattle. M agrees to pay an 10,000 rupees if two parallel lines should. These are the contract which is void ab initio because of the impossible event. मैं तुम्हारे लिए चांद तारे तोड़ के ले आऊँगा अगर तुम मेरे साथ मेरे को ये बेचोगे, मैं तुम्हारे लिए एवरेस्ट की चोटी को फांद दूंगा. ऐसे जो इम्पॉसिबल इवेंट हैं अगर उनके बेस पे उनकी कंसिडरेशन पे कोई एग्रीमेंट होता है तो all those contracts are void. If an interstate deceased has left, no here qualified. It is the section if I am not wrong of the Succession Act is section number 29 of the Hindu Succession Act, popularly known as this process is a cheat when there is a no heirs is left, first, second, third, agnet, cognet, then the property goes to the government, and it is known as the process of escheat. The headquarter of the SARC is Kathmandu. Kathmandu is the, what is the Kathmandu? Kathmandu is the capital of Nepal.